So, what I thought I should do today is to actually pick up a little bit on some of the previous speeches and talk about state aid modernization, just to briefly recall why we did it, but also then to report a bit on where we are in terms of the objectives that we set at the time. Are we actually reaching them? And from that then to look at three areas of priority, which I think keep colleagues in Brussels busy, namely energy, banking, and our probe into aggressive tax planning practices. And then at the end, to zoom out from that and look forward to what the future may hold for us. So that's the basic plan for today. And as I said, I'll start by talking a bit about state aid modernization, where we are with implementation. Now, brief recap in terms of objectives at the time when this was launched. Obviously, the basic reason why there is a chapter on state aid in the treaty is that state interventions can lead to distortions of competition and undermine equality of conditions in the internal market. So that is clearly something that we need to be watchful for, and the objective was to strengthen our capacity to reach that objective. There was also a concern about the efficient use of public resources for growth-oriented policies. That obviously is conditional on there being a competition distortion to begin with, but if there is a competition distortion, then naturally it makes sense to ensure that where monies are allowed, they go towards growth-oriented policies. And last but not least, I'm working in a reverse order from the slide, as you can see. The objective was also very much to strengthen the quality and the speed of Commission scrutiny. Especially the speed was a bit of an issue at the time, may still be, so we set out to improve that. In terms of the tools that we used, there was a clear objective of working through streamlined tools that were also more harmonized to enable faster decision making. The, I think, corner piece of much of what we've done consists of an extension of the JIBA, as Gert has also explained earlier on, effectively shifting much control from the Commission to the Member States. In order to help, we set up a partnership with Member States in which we also provide detailed guidance to help them police the system. And therefore, the objective was to focus and Commission on enforcement on cases with the biggest impact on the internal market. That then led to a managerial decision to reallocate, restructure the services to reach those objectives. Now, the picture of the iceberg is something you might have seen before, but effectively what we tried to do was to limit direct Commission control to the tip of the iceberg above the waterline, with the bulk of the iceberg below the waterline being under the primary control of Member States through the enlarged and simplified JIBA. Naturally, Member States under the treaty are not in a position to decide on compatibility issues, but they are qualified to ensure consistency of implementation of aid measures with the conditions which the Commission has set for compatibility under the JIBA. So that is a little qualification. Now, naturally, the risk with icebergs is that they can lead to shipwrecks. So in order to avoid that and to deal with some of the legal certainty concerns, which we incidentally also heard about this morning, we set about to develop a partnership with Member States where we work very closely. We have country coordinators in DG Comp nowadays. We have portfolios of Member States' cases, which we try to discuss with Member States to ensure facility of treatment. We've done a lot of work in terms of guidance and clarification, interpretation, and worked on joint training actions. So that that battery of interventions was aimed at ensuring that Member States were equipped to take on their new responsibilities. And I think, as Gert showed earlier today, the flip side of this greater empowerment was, of course, that ex post we would check through monitoring, which is a sampling-based approach where we look at whether measures under schemes are actually compliant with the conditions in the schemes and the JIBA. We've launched, I think, an unprecedented evaluation exercise which effectively requires member states for large aid interventions to set up an evaluation plan, which is a precondition for approval of the measure, which subsequently will feed into the evaluation and assessment of the functioning of the existing rules. Now, I can report that to date we have evaluation plans covering more than 30% of all aid by expenditure granted in the Union. So it's very significant. And obviously these evaluation results will only come in a while, once these measures have been implemented, once there's something to evaluate. But I consider that this is a transformational aspect of state aid modernization that will reap its fruit when we get to the next revision of the state aid guidelines, because when we did state aid modernization, we simply couldn't draw on such an empirical basis. And then there is transparency, which effectively requires for all larger aid amounts, as of July of this year, a publication, so disclosure on a website. The Commission has worked very hard to make a tool available to Member States, which is up and running, and which will give everyone active in the marketplace, but also citizens, an opportunity to look at what is being spent where, on what, and who actually receives the state aid. So we think those are important parts of a wider package where there is significant reliance on Member States taking up responsibility, Commission pulling back, only concentrating on the big issues, but we have these guarantees in place. Now, of course, as I said, the question is it working? Most of these measures were introduced in 2013, 2014, and you can see here that when we look at notifications, there's been a dramatic change, with notifications dropping very significantly as per the objectives set out under some, and correspondingly, of course, the percentage of measures, state aid measures, that now fly under the JIBA has increased dramatically. It's more than doubled. And if you think about this, it means that of every 6 measures in 2013 which were being notified to the Commission, nowadays there's only 1 left. So it's a dramatic reduction in the way the system works. And this is exactly what we wanted. It's an achievement which I think we need to celebrate together with Member States, because obviously it's only because of their efforts that measures now fly under the JIBA, and we've spent, through the partnership, a lot of time working with them to actually achieve these objectives. So it's a joint effort in which Member States and the Commission have, I think, dramatically reoriented the functioning of the system. Now, this next slide, I think you have handouts which are easier to read, gives you an overview of the share of block-exempted scheme as a percentage of total aid measures by member state. The bars in orange give you the average percentage in the period 2011-2013. In light blue, the average percentage 2014-2016, and the black bars give you the values for 2016 up until July. Now, obviously, as I said, in 2016 we hit in Europe on average about 90%. That you can see in the rectangle in red. But what is quite interesting, I think, also is the distribution in 2 senses. One, the variation between a country like the Netherlands with a block-exempted percentage of aid that is now approaching 100% to Luxembourg and Cyprus, which are still much lower, well below 50%. So in that sense, there's still a lot of possibilities in member states to catch up. And secondly, the deltas have also been quite significantly different across member states. Some member states have made huge strides, like Slovakia, for example, or even France. So the increase in the use of the block exemption has been dramatic. Others have seen much less significant developments there. So I think my own take on this is that we've made a huge push, good results, but there is still more to be had. And I should add to it, I'm afraid we didn't manage to finalize the statistics for today's presentation, but we've looked at the existing caseload as it stands today and distinguished between measures that were notified or complaints that were made prior to the entry into force of the State Aid Modernisation Programme and those that were submitted later. And it's interesting to note that there's still quite a lot, more than 50% actually, of what is in our caseload that predates State Aid Modernisation. So what that means is that once we digest that backlog, if you will, then the system will reach steady state and we'll have much lower numbers. So in terms of DG Comp's, my own service's ability to work as per the objectives that I presented at the start of the presentation, that comes with a bit of a lag as the system processes the cases. And that also, I think, explains on this slide why there has been a drop in the average duration of procedures, but the drop is not particularly marked. I'm not pleased with this. It's progress, certainly, but more progress could be had. And I think one of the important reasons, as I said, is that the backlog of pre-State Aid Modernisation cases is still very significant, so the system is still coping with the heritage of the past. What is, however, more worrying from one perspective, and from another perspective actually is encouraging, is the evolution in the number of complaints, which has actually been relatively stable. Now, we had expected when we launched State Aid Modernisation that the drop in the number of complaints would be about 25%, and that has not materialized. But what we see is that the complaints we're getting are progressively, increasingly so, becoming more substantive, more interesting, pointing to more material issues. And that, of course, from a state aid enforcement point of view, from an internal market point of view, is a good thing. The other positive element here is that the average duration of complaint procedures, so for these new generation of complaints, has decreased quite significantly, from 14 months on average to 10 months. And that despite the fact that these complaints now, as I said, are on average much more complex. So we're dealing with more complex, relevant complaints in a significantly speedier fashion. So I think in this respect I would like to make a point which, in a group like this, where there are many member states representatives and hopefully also representatives from national courts, is I think important, which is that some of the complaints we continue to receive, are actually issues that could easily, and sometimes are, dealt with by national courts. As you know, national courts have the legal powers to rule on whether a measure is aid or no aid. And as you know, in principle, when a measure is found by a national court to constitute aid, then this measure must be terminated and the aid must be recovered, because national authorities have no powers to declare a measure compatible. So complainants, in terms of effectiveness of the remedy, may be well advised to turn increasingly to national courts for matters where the interpretation of the aid question depends crucially on national and sometimes local or regional institutional settings. And we, from our side, will increasingly, in our priority setting, give complaints that can be dealt with in this manner low priority, because in terms of the efficient organization of work, we do not believe that we are the most obvious port of call. Don't get me wrong, you have every right to a Commission decision if you have legal standing. We will not deny you that. But what we do say is that in terms of our priority setting, we will take this factor progressively into account. So I think clearly too early to come to a final verdict, but certainly in terms of the procedural functioning of the system, there is quite a lot of good news. The other thing that I should say is that the freeing up of resources this has brought has allowed us to concentrate on priority sectors in a way that I think, in a resource-constrained environment where the Commission as an administration is shrinking and where DG Comp is constant in terms of resources, where we would not have been able to go without this reform. So the reform has also helped in making proactive enforcement on big issues, big on big as it is called in the Juncker Commission, possible. 3 sectors are particularly relevant, as I've already said. First concerns energy, where the progressive opening of the market on the one hand, but on the other hand also the very significant interventions by member states to deliver public policy goals, be it for renewables, be it for infrastructure or for security of supply, has increasingly led to the granting of state aid. And in order to look at one factor that is relatively new and potentially very distortive, namely capacity mechanisms, we have launched the first ever state aid sector enquiry, which is a tool that is now possible under state aid modernisation because we introduced it in the procedural regulation as part of this process. So that enquiry is about to finalise. I think it's no surprise that the final report will come probably next week as part of the winter package, if the winter package is adopted next week. And that report will provide our assessment of the functioning of capacity mechanisms from a state aid point of view. So clearly there's a very strong correlation with the regulatory agenda, which is why aligning it with the winter package makes a lot of sense. But there is no doubt that these measures are typically state aid and that therefore state aid rules apply and that we have to calibrate them correctly. I think the underlying logic is simple. We want to avoid that we recreate national borders in the internal market, and what is more, we want to avoid a situation where across energy technologies the investment signals are unduly hindered and the sector becomes ever more dependent as a result on state aid. But in energy there are other important priorities as well, as you know, notably the support of renewable energies, which are a translation, if you will, of these schemes are a translation of the policy objective of reaching a preset target for the share of renewables in the energy mix. Important priority. Schemes tend to be state aid. There's been some uncertainty about this, but I think the courts have clarified the legal status of most of these measures. And under the guidelines that we apply in this area, the Energy and Environmental Aid Guidelines, we are now processing essentially all of these schemes. We've made good progress already, and we hope in the course of next year to have processed the bulk of these schemes. Important because what started out as an infant industry with a small market share and no participation effectively in the market has now become a dominant player in energy markets with very significant implications given its very low marginal costs. Therefore, these state aid guidelines, to simplify, require market integration for these interventions to be found compatible. And member states have been amending, adjusting their schemes to reach this. Interestingly, because these competitive elements are a requirement now, we have empirical evidence, and the empirical evidence shows that the introduction of tendering, which is a requirement under the guidelines, has led to a very significant drop in costs. So we can demonstrate that competition, as you would expect, works, that it saves an awful lot of money for the state, but also that the competitive allocation process leads to more dynamism and hopefully also to more innovation. Coal is another important area. The Commission adopted a decision on Polish coal. Under the coal decision, which is a council decision, we are effectively making sure that closure aid is granted and that member states close unviable coal mines. It is noteworthy, I think, that despite all of the sensitivities, the case that was decided last week concerns Poland, which has a significant coal sector and which is in the process of an ambitious restructuring effort, closing a significant number of coal mines. And finally, I will not say much about that for the reasons that we don't have too much time. We put a lot of emphasis also on trading platforms and exchanges, which are increasingly important as the market takes off, and which, of course, require scrutiny to avoid difficulties in terms of market functioning. So energy has become, I think, one of the biggest areas of intervention. We're using tools that did not exist before State Aid Modernisation. We're taking a sectoral approach through a capacity, through a sector inquiry, and therefore I think we are also looking very much from an economic perspective at how state aid control plays out in this sector. Now, tax rulings, it says tax rulings, cases. This is part of our initiative to look at state aid in aggressive tax planning practices. It's a wholly new initiative. It's a fully ex officio initiative. All of the people working there were working on something else 2.5 years ago, so it's a genuine ex officio drive, triggered by concerns about the distortive effects that such measures have in the internal market, and also against the background of the obvious concerns about the wider ramifications of such potentially illegal and incompatible state aid. As you know, and there was a session on this which I did not fully attend, but first decisions were taken in October of last year and then earlier in this year concerning Starbucks and Fiat, the Belgian excess profit scheme, and the Apple decision. We have 3 open ongoing cases concerning Amazon, McDonald's, and a case concerning what I think is now called Engie. These are important cases. At this juncture, these cases are very much dealing with important precedent difficulties we see in the way systems function, and by tackling these cases we also believe that we can provide clarity to practitioners. Now, let me clarify that obviously we have no issue as such with tax rulings. Tax rulings are important to provide certainty ex ante to companies, so that is absolutely fine, but obviously, like any other tax measure, like any other state measure, it needs to comply with state aid rules. We've clarified that what we look at are outliers. We're not dealing with cases that fall in the obvious grey zone of interpretation when it comes to important technical questions such as transfer pricing. We're looking at outliers, and we're doing that on the basis of a very unique database which was collected in all member states that grant tax rulings on the basis of a sample covering 3 years, where we then selected essentially 1,000 rulings concerning about 300 companies. So we have, I think, a unique overview of tax rulings in Europe. These are, of course, normally subject to fiscal secrecy. Until recently, they were not shared across member states. That's changed a little bit following regulatory initiatives in this field. But when I say that we are going after outliers, it is not just an abstract statement. It's based on our reading of what we have on our plate, which I think is a rather representative sample. In terms of guidance, guidance comes through taking decisions, but we have tried already at an early stage to codify. We've done that in the notice on the notion of aid, which was discussed before lunch, and also in a dedicated working paper on state aid and tax rulings that we issued in June. It's clearly an ongoing initiative that I would say is far from completion. This is a big area, an important area where we have recently strengthened our troops, and we are clearly assessing information that is reaching us through market information tools, but also reaching us through other sources, analyzing what we have in our collection of tax rulings to see whether we effectively deal with the vast panoply of issues that arise in this context. We are not the tax police. There are many tax planning issues that fall outside of state aid control because they are general measures. We do not want to be the tax ruling police. We can only deal with issues where there is state aid, and as I said, we go after outliers, not cases in the grey zone. We think this work, however, is important, and definitely this is a priority that I see continuing for the years ahead. Third element, and this I should add is less new. In many ways, it's a priority I would rather not see at this juncture, but it's there. It continues to be important, and that is state aid control in banking. As you know, during the banking crisis, in the absence of European tools for the coordination of restructuring and resolution of banks in difficulty, de facto, the state aid framework and the dedicated rules we drafted functioned as a sort of de facto and very imperfect EU resolution framework. It's been used to a very large extent to deal with banks that got into difficulty. 30% of the EU banking sector by assets received state aid and is therefore under state aid control because restructuring or resolution decisions were adopted. So it's very significant. And what is interesting is that we have seen quite a lot of market exits. About 40% of our cases concern market exits. So the idea that in Europe we don't close banks, I think that is demonstrably wrong, empirically disproven by this analysis. These are, on the whole, smaller cases, as you can see from the comparison of the statistics on the number of cases that concern liquidation cases and the assets concerned. So 40% of all cases are liquidation cases. 1 trillion of the assets out of 13 trillion of the assets concern liquidation cases. But this is not very different from the US, where any resolution and liquidation has only concerned, with one big exception we all know, smaller institutions. Now, of course, now we have banking union that was built, a regulatory framework built on the lessons of the crisis. However, my point is that state aid control is still there and the state aid rules have not changed. Actually, they remain relevant for various reasons. The first reason is that any support for resolution coming from the Single Resolution Fund that has been set up for countries that are part of banking union is subject to state aid control, exactly the same rules that apply outside of banking union land. And secondly, because there are still interventions where state aid does not lead to resolution, namely precautionary recapitalizations where banks have a little bit too little capital to deal with adverse circumstances. Those don't require resolution under the new rules, but any state aid given to deal with those capital shortfalls is still subject to state aid control, and we've seen a lot of that. And finally, I should add that cases where member states have pursued non-aid interventions, so interventions on market terms, have actually become very important, maybe not unsurprisingly so, and these are often submitted to the Commission for clearance. So state aid control remains important because the banking difficulties have not gone away. We have not been able to downsize our activities in this field, and I very much hope so that when I or my successor comes to a future conference, the message on this point will be different. Now, looking ahead, as I said, we are reaping the results of the changes that have been introduced under State Aid Modernisation, but it's not fully completed. There was already a reference to the ongoing review of the GBER that deals with ports, airports, and some legal tidying up, if I can use those terms. That's a small-scale intervention. However, for the sectors concerned, very important. We'll further expand the scope of the GBER. But the real question, of course, is what happens afterwards, because, as you probably know, many of our rules expire at the end of 2020, including the GBER itself. and reviews of some of the tools are required, or have been envisaged, I should say, at an earlier point in time. And the de minimis regulation itself expires at the end of 2018. So, this is not a static picture. This is a picture of increasing, continuing reforms. We're now at a stage where we're reflecting on possible reforms post state aid modernization. I think the theme of simplification has not gone away. We are always on the lookout for ways of simplifying the system without throwing out the baby with the bathwater. We're also keenly interested in ensuring that when we are big on big, we're capable of being effective and quick, so that remains an important theme. And when we're small on small, we really want to be small on small, and the question is whether beyond the GBA there is scope for being small on small. So that's where we are. I think we're implementing, reaping the fruits of state aid modernization. More to be had, results to be harvested, important big on big enforcement cases in banking, in energy and in tax, and preparing the ground now to look ahead at the future for a further review of the system. I would be interested if there are any comments, questions or suggestions on that further review, because obviously we will be listening very carefully to what practitioners have to say about it, both in member states and in the private sector. Thank you very much.